Yeah, Alex?
Thanks. So, a question for Professor Kysar. All right, Doug. So this is very powerful presentation. No reactants, please. All presentations were great. So, cost-benefit analysis is not great. I agree, but I want to push you a little bit on whether what you have in mind is better, and whether cost-benefit analysis is sort of like democracy. You know, it's a terrible system, but the best one we've got. So it's value ignorant and value laden at the same time, and it's susceptible to abuse and gaming. Like, granted, but at least it imposes some constraints, and possibly produces fairly stable policy making. And part of the reason constraints are there is because, of course, administration can ignore scientific evidence, but it's pretty obvious that that's what they're doing, and so, that kind of goes into big pile of things, and then administration changes. So you're suggesting, let's bring, or we have to bring back moral or ethical judgments into environmental policymaking, and I expect all policymaking, right? Why is environmental different from food and drug or anything else? And whose judgment we're bringing in? You say, well, it's environmental laws authors, us. And here's I'm starting to have problems, right? So it's a pretty divided country. And that's not so unusual. And you said, well, Nixon was created EPA, and it was a bipartisan support for environmental legislation in the 70s. So that's great that it worked out for environmental legislation then. But it surely is not very promising going forward, right? You say, oh, Civil Rights Act. You give me Civil Rights Act, right, as a moral value-laden sort of legislation. I give you Defense of Marriage Act, right? It can cut both ways. And from the sort of instrumentalist point of view, it creates tremendous, if you have changing values at the helm, so to speak, right, and morals at the helm, it creates tremendous instability in policymaking. And in addition, if you are caring deeply about your moral judgments, it also creates tremendous harm to you. I don't want to say disutility, right? But harm to you when things like Defense of Marriage Act are enacted. So do you see any way to constrain that? Or how do you feel comfortable that, 4 years from now, 8 years from now, the moral judgments that will go into environmental law will be very different from your moral judgments?
It's a great question. Internationally, I think there's a hope that democracy leads inevitably to sustainable environmental policies. And so there are big conventions that give citizens a right to environmental information or a right to participate in environmental policymaking with the idea that that will inevitably lead to enlightened decisions. And I don't have a reason to believe that to be necessarily the case. You kind of pick your poison. The fact is, though, that each time that Republican Congresses have made a big push to repeal one of the kind of landmark environmental statutes like the Endangered Species Act or NEPA, or change the way in which Clean Air Act is implemented, each time that there's been an effort to have that happen, there's been massive pushback, and those statutes have had a kind of symbolic durability that suggests, perhaps at least with that existing framework, that the commitment has been sustained. And if you look at the ways in which those statutes are designed and implemented, they do have a kind of set of pragmatic alternatives to full-blown cost-benefit analysis. There are ways in which they are cost-sensitive, so it's not the case that they are draconian or require the shutting down of industries without any attention to the negative effects. Right? It's just that it's done so in a kind of much more pragmatic way. Pragmatic also in the sense that it reflects an allocation of decision-making authority among the branches. So Congress decides that clean water is worth so much to society that we're only going to require the best available technology to reduce it, irrespective of the cost. And then the agency engages in a kind of more or less technical engineering judgment about what is the best performing technology out there that won't bankrupt an industry. And then industry is given flexibility to achieve the performance standard of that best available technology. We are now seeing an effort to change those traditional ways of implementing environmental law by seeding cost-benefit analysis into the front end of the regulatory rulemaking so that the performance standard is not dictated by the best performing technology, but rather dictated by where the cost-benefit curves cross. There's actually a very important Supreme Court case right now deciding whether that is permissible under the Clean Air Act as a matter of statutory interpretation. What I find regrettable about it is not just the fact that often we get worse results. You know, when you put in place things like lack of information and contested valuations and a lot of kind of real-world constraints on the decision-making frame, it's not necessarily optimal to deliberately seek to optimize. It may be more optimal to adopt some heuristic approach. And a lot of our most successful environmental policies can be retrospectively shown to have sailed through a cost-benefit analysis, but at the time of the decision, we didn't have the empirical understanding necessary to generate the cost-benefit numbers. So for instance, we phased lead out of gasoline, and then later that generated a basis for epidemiological studies about the relationship between lead and health effects, which then provides the quantitative basis for doing cost-benefit analysis. Had we done CBA at the beginning, we never would have phased out lead because we didn't have the data necessary to produce it. So that's a kind of just practical point. For me, the symbolic point, the kind of more squishy point, is that the aspirational standards of these early statutes, the best available technology, or every worker's entitled to a safe workplace, or national ambient air quality has to be protective with a reasonable margin of safety so no one suffers adverse health effects. Of course we're going to fail those. Of course there's going to be a gap, a lamentable gap between society, statutory aspiration and actual achievement. But the gap is important. The gap is a moral remainder. It's a kind of, it's the regret that has to stare us in the face and that makes us bound together into a commitment to perpetually be dissatisfied with our implementation of this statute. Whereas when we talk in a language of optimization and inevitable trade-offs, it doesn't leave any room for that moral remainder. The remainder has to be rounded to zero because nothing within the optimistic framework allows for that excess of meaning. And I think that's a danger that's difficult to quantify and kind of formalize, but I think it's a real one.